and we'll be fine. We'll pull out those electropharograms. He just calls him and says there may be some bad publicity for you because now he's realized that something wasn't in a report that should have been there, and he puts him up there for all the world to see with no prep, no direct, no attempt to try and even cover his tracks, thereby just assuring that he's thrown everything away and taking no steps to do so. And I would contend all those activities as someone, again, I'm not saying our argument as to what he did was not violations, but I would contend all that evidence is consistent with someone who gets something, doesn't really pay attention, and just sort of throws it in the back and doesn't pay attention to it until a couple of days before trial, like they used to do in the old days, and look at everything and come in and try a case. I would contend all that activity is much more consistent with that. There's nothing that's come along that's required him, other than being questioned in court about the reports, that's required him to sit down and focus on the evidence to be ready for any particular type evidentiary hearing, because there's been not the first evidentiary hearing of any kind before Dr. Meehan testifies. He didn't even come and try and object to Dr. Meehan testifying. The panel may be aware, I don't know that I've ever been aware of having access to an expert like that pre-trial. I don't know that I've ever had the opportunity, other than being able to talk to him, I've never had the access to be able to cross-examine an expert pre-trial in court.
Well,
the other
what you interpret as something being extremely generous can also be interpreted as throwing him up there with no notice to the defendants or opportunity to prepare to examine him. What they've done was request the opportunity to examine him, and we're kind of getting off onto the details. But you see my point. I mean, it can be interpreted as a calculated move to say, maybe I'll throw them up there, maybe they won't be ready for him, and then that'll be their only shot.
Right, and all they had to do is they could have continued it and asked for another hearing.
Well,
it was their decision, or at least one person's decision. At least one person's decision to go forward.
Hey, go. You got it.
That's correct. It was his, but they could have continued that and had time to get prepared. Obviously, they didn't need it, and they did quite a good job. And probably it was to their benefit they didn't continue it. But the point is, I don't see how putting somebody up there unprepared, not preparing your own witness to go up and testify, or if you know that you're trying to hide something to that witness, not at least addressing that issue with that witness at some point, shows how he's trying to hide anything. Again, it's more consistent with someone who just sort of goes along and puts his case out there. Well, I would contend.
Yeah, I see your argument.
Again, in hindsight, we're not saying, and Mr. Nifong has not said, they're not violations. What we're contending is a person in his position has not committed these violations intentionally, and would not lie to the court, and we would ask as such. You also said as part of your duty to make sure that someone who maybe saw things as myopically as he did or not as careful as he did would not be in a position to do that again, and I believe Mr. Nifong's statements yesterday remedied any issue to that regard.
As a district attorney, but not as a lawyer.
I understand that, but the issues we're talking about are issues that charge to actually charging an individual and turning over potentially exculpatory evidence, which only is addressed as a prosecutor.
Well, and that brings up an issue I wanted to bring up with you, which is in my series of questions to him about when, if ever, he took into account the rules of professional conduct in doing anything in this case. And his, basically saying, my interpretation of his answer was, despite having been alerted to that by Mr. Cheshire's March 30 letter, that indeed he just pretty much never took into account the rules of professional conduct in the way that he prosecuted this case. And as lawyers, we are deemed to know what's in the our rules of professional conduct, and they're not all obvious. I mean, they're not all do unto others as you would have them do unto you. I mean, some of these things, indeed, the publicity rule is not obvious. But what concerns me, specifically in regard to Mr. Nifong, is that in order to act ethically, you have to be thinking about what the ethical issues are. And if your thinking doesn't include an ethical component that guides your actions, why should he, intent to do something bad doesn't matter if he seems to be incapable of acting in an ethical dimension?
Well, I would disagree. He's incapable of acting in an ethical fashion, considering one is that you haven't even seen the first complaint against him during a fairly lengthy and distinguished career, and secondly, he may not be familiar with the specific rules of the Code of Professional Conduct, but I believe he is familiar with the spirit and has addressed it at various times. Of course, now I'm sort of arguing, you're asking me questions that are outside the record, but I believe so I have to address my arguments inside the record, but everything he's done, Mr. Smith's testified as to a high-profile case. It's a different bird, and everyone, a number of people have made statements early on they probably regret, but he stopped. I mean, he realized it was wrong and he stopped. That didn't drive away the publicity, but he stopped. And then
he didn't stop because he realized it was wrong.
Well,
that wasn't his testimony.
He stopped.
He did.
And then friends told him it wasn't working.
He did. He made a decision to stop that was not based on ethical concerns, but upon something else. That
well, I don't know that if one has acted unethically and then stops acting unethically, you are to punish someone because the reason they stopped that way was not because it was just to be ethical. It was for other reasons. I mean, I think we're to look at the unethical activity and see clearly he's learned from that, has not repeated it. And then almost all of the other ethical concerns, there are a number of complaints, there are a number of allegations here about discovery, but really it all goes to the unidentified, everything. There's volumes and volumes of discovery that's produced in this case. He's produced a ton of discovery, a ton of documents, which makes things difficult. All the violations of discovery, and again, if I'm wrong, I'm sure you'll correct me, go to the unidentified DNA. I mean, all the rules, we've got 20-some contested issues. You've got the first couple of contested issues that deal with the pretrial statements.
Well, it all comes down to pretrial statements and the handling of the DNA.
And the handling of the DNA. So indeed, if he is correct and he's handled everything else properly except for this one thing he didn't realize they got, and then he got it, he's not out there just acting unethically. So if indeed he's correct and all of his mistakes and misstatements have come from the fact he thought they had this documentation, then all the other discovery he's complied with in this case is correct. So it appears as if it's dealing with a number of different issues, but it really only deals with one. Because everything else was produced. And all the things that were clearly exculpatory were produced, and all the other bad statements were produced, and the way they know about all the we've had some cases before the state bar that deal with statements that have been buried, that could potentially, that would have freed some people who, God forbid, one ended up on death row. She gave a bunch of inconsistent statements here. You know how everybody knows that? Because he turned it over. If he was trying to hide something, if he was trying to sit on something, why doesn't he sit on something that actually matters in this case? And he turns over the things he could have hidden. The one thing at issue is something he could have hidden.